Hi, everyone. It's Grant Abbott speaking, and welcome to the launch of the Business Protector. I sort of noted this was coming around probably around about 3 or 4 weeks ago. We were looking at licensing and licensing of property. So with the Business Protector, you'll see as we go through, essentially it's a transfer and also a license back of key business property. So it's not an overly sophisticated strategy, but the end benefits there. There's Mr. Tim. Sorry. Oh, there we go. We've actually got you there, and we've got you there live. Tim, where are you?
I'm at a outsourced financial professional development day. I've just got myself a coffee and eased out of the day to come and join this very important webinar.
Yeah, fantastic. It'll be a good one. So we're getting a bit of background noise there, but what I'll do is I'll call upon you in probably about 10 minutes, if that's okay. So let's go through the Business Protector. A lot of this is actually hats off or hat tip to Mr. Tim talking about risk assets, etc. So it's a really important point. I've seen so many, and I'm sure Tim has as well, that people utilise their spouses for the purpose of holding the risk assets and try to give protection around there. Unfortunately, that is a red rag to a bull for a divorce. In the event that something happens in a marriage, you're in a very invidious position if your business is now being held hostage to an opposing family legal counsel. So it's absolutely crucial. So what I want to do is go through the various issues in the Business Protector. I'll show you how it works. Then we'll get in Tim for a bit of a chat around it. And then what I'll do is I'll actually do the documentation at the back end to show you how it works. And even going through the slides this morning, my head was popping with a couple of other strategies, synergies, and other documentation that can be put into this one interview form. And you should know by now that certainly at LightYear Docs, one document is never good enough. If we can, build a whole solution into one interview or one visit, essentially that's where we want to be going. So let's go on and have a look at the Business Protector. Again, you've seen this on many occasions, and it's really important. Obviously, we've got our client's castle, and that's where all their family wealth is really residing. But within that castle, to a certain extent, whether it's the big pillar here or somewhere, maybe this little one here, is the family business, which may be run through a trading company, might be run through sole trader, partnership, or alternatively through a discretionary trust. These are all the tools that we use as accountants and also financial planners and lawyers to really build a really good solid base for our client's business. And of course, with LightYear Docs, also the Succession Asset Protection Estate Planning Advisors Association, we're all about bloodline planning and protecting family wealth. What we're doing now is we're drilling right down into the very forefront of our business, and we're going to make sure we put a big moat around that. So when we have a look at this, this is a typical diagram that I'll put up aboard when I'm doing training. For those of you who have been smart enough to secure a ticket for tomorrow's Master Strategy Day with myself, Tim, and also Michael Jeffries, you're going to get so many strategies. This is one of them. I won't be able to go into a huge deep dive there, but this is certainly one of them that is absolutely crucial for you to get on top of. Not only for your clients, but also for yourself. And look, my estimate, it's around about a $7,000 to $10,000 job, and there's some great ongoing admin with it as well. So for me, it's a very exciting strategy. And again, I'll bring Tim on in about 10 minutes and we'll go through it. But if you have a look here, this is our typical scenario. We've got our discretionary trust in the business. It could well be in a company. We've got our trustee company up in there. We've got our bucket company there as well. So that's pretty stock standard. We may have an Smsf that's sitting off the side. Here you've got your family protection trust and also then a bucket company there potentially. Over here, we've got assets in their own name, house, investment properties. I've talked to you many times about the dangers of of dying with a structure like this, particularly if you haven't got the family protection trust, because the house, the investment properties, anything that's sitting in the client's own name is exposed to family provisions claims. Now, there's of course a benefit there with discretionary trust, but I'm not going to go into that in huge detail, mainly because we'll look at that from tomorrow's perspective. From that one there, obviously all our jewels, our business assets are sitting in the discretionary trust or a trading company. And each one is going to be quite separate and different, but there's vulnerability with that, and we need to face up to that. I was at a session the other day with Ben Walker from Inspire Accounting, who again leads a great young team there. Very exciting, love the strategies, love the solutions. But I did note there that Ben said, well, he's had 3 clients that have come to him and asking for risk protection. And I think that's pretty important, that if you went out and asked all your clients who've got businesses, do you want your business to be protected from litigation? And litigation may be by way of someone falls over in the showroom, someone takes a pot shot, and don't forget Fair Work. Obviously, it's very easy to take pot shots there, which are very expensive. And of course, divorce as well. If all the assets are in the wife's name and you get divorced, what happens to that business? In fact, if she or he, I should say, are very vindictive, they can run the business to the ground, and I've seen that happen, and you've got absolutely no say in the matter. I mean, of course, you can do injunctions, but if it takes 2 to 3 years to get through the courts, you're pretty well stuffed. So divorce, and of course, death. What happens on death? I mean, we have started that way. We've gone through and done the successor director solution. And by now I would have expected that all of you would have gone out to your clients, and particularly those ones who've got sole director, sole shareholder companies, have gone out to all your clients and told them about the absolute importance of getting the successor director solution on board. This is all about business continuity. If you're like me and certainly Tim and Mike and all that, that your businesses are your livelihood. We've got our superannuation, we've got our other assets, but essentially the engine that is driving our family's wealth, our family's legacy is our business. So by all means, it must be protected. The successor director solution is a small infinitesimal amount of it. So what we want to do is we want to make sure that we go back again, if we go back to this moat, and we just focus now on really putting a moat around our family business. And for me, the business protector is the way to go. And look, at the end of the day, as I said to Ben, if your clients are coming to you with that solution, it's now time for you to get the business protector up and running for all your clients. And no doubt Tim is already starting to build some great marketing there for all the Change GPS members, which I know many LightYear Docs members are as well. So the solution is the business protector. For that, when we have a look at a transfer of our business, or we sell a business, we end up selling goodwill. But at the end of the day, is there goodwill in a business at all? We can start to break down our business into a multiplicity of parts. So, for example, one of the most valuable parts of any business, and certainly why a number of larger businesses will buy smaller businesses, are for databases. You can see that when you have a look at, for example, a Class who bought Now Infinity and also Reckon Docs. Now, do you think that they bought Reckon Docs for the simple fact of using their document solution or their corporate management solution? Absolutely not, because they've already got those on foot. It's about migrating the existing databases over there. So that essentially has been a play of paying $16 million for the database of effectively Reckon. And they probably paid 4 to 5 times for that, which is smart, because have a look at Class Super, they're probably trading at around about 28 or 40 times, I'm not quite sure. And if you look at that, bringing that on, it's a very, very smart move. But again, essentially, you just want the database. You don't necessarily want the staff, etc. So again, database is absolutely king for your clients. Business processes, the same sort of thing. If you had a look at, for example, Change GPS, or for example, LightYear Docs, a lot of it is going to be the IP, copyright in each and every document. the IP, the logos, etc. All of those things have an intrinsic value, and we'll talk about valuation a little bit later on. But I did this with, again, David Dwyer. I met with a couple of his clients the other day. I had a client who was a plumber. So again, some of the assets that are sitting in there that were sitting in the discretionary trust, such as cars, which were full value, sitting in there, had no encumbrance on them, they weren't subject to a lease, they could be transferred over. Likewise, tools, anything that sits inside that business can effectively be transferred over. And what we're doing is we're trying to mitigate any risk of litigation so that when someone comes and looks for that particular asset in whatever the trading company is, the trading entity, there's nothing there to any great extent. And again, this, look, honestly, this is my favorite strategy of all time. The protector, absolutely, I love that, but this is the business protector. This impacts me and also my family. So what we want to do is we want to get those assets and we want to identify them. I'm going to take you through how we're going to do that a little bit later on. But we want to identify those assets and start to split them out and then transfer them over to a separate company or trust for protection purposes. Now, what will happen there is that now they are over in another entity. And there's a couple of things that happen there. One is that if we've got the existing trading company, the existing trading trust, effectively, we can license it back to that entity. Alternatively, all our good jewels, our value and all that is basically sitting inside now a new family protection trust, leading member trust or company. And so effectively we can license that back to our existing entity, or we can wind up that existing entity and go and start up a brand new entity. Or more importantly, if it's franchisable, we've got all those crown jewels there that can be licensed out to not only our trading entity, but any trading entity for that matter. So with one fell swoop, we've broken apart a business, broken it into its constituent parts. We've now transferred that property over, and more importantly, we're going to be in a great position of licensing it back. So when we have a look at what it looks like from a pictorial point of view, and this was from the other day when we did our 20 strategies in 30 minutes. In fact, it was 25 strategies in 30 minutes. For those of you who got blown away by that, again, hopefully you're coming to the Master Strategy Day tomorrow, where we've got a lot more time to do a deep dive on the application of those strategies to 3 case studies that Tim has worked on. And I'm going to get him to talk in a very short second after this. So when we start to have a look at it, we've got our business operations, and I've identified here, this video will be up and ready for you in the next couple of hours, and I'll put obviously the slides there as well. So I've got our logos, trademarks, business processes, marketing processes, copyright, client database. You know, there might even be properties or 2, but obviously with those we have concerns around capital gains tax potentially, and also stamp duty. Now, what we do is we set up a family protection trust or some other clean vehicle. Now, we might have a discretionary trust that has simply got investments, for example, shares, property that has got no real litigation exposure or has got minimal risk exposure. Therefore, we could actually take that and then upgrade it to a leading member trust, which essentially is there for lineage and bloodline. So for your clients, you're actually doing 2 things. One is you're protecting their business assets. And this is the kicker. Not only are you protecting it, but you're building those, the income and the capital and the value of that protection is going to go down for the benefit of lineage and bloodline beneficiaries. So you can it's almost like a business protection on steroids. I don't know why no one's thought about this before, but to me, this is, it's a great strategy. So what we've got to do is just do a few watch outs. So in terms of the watch outs, it's very hard because they're going to be related parties to do nil consideration. Because what will happen is the capital gains tax rules will deem there to be a market value consideration between the related parties. So we've got to watch out for that capital gains tax side of things. I'm going to address that very shortly in doing that. In terms of bankruptcy, and this is pretty important, because if we do pay full market value consideration, Section 120 won't apply to us. So there's no clawback, which is even better still. So we need to make sure that we do full value consideration. The only time it's going to be voided if the intent was to actually defeat creditors. So if you're in a solvent position, then look, it's going to be very unlikely to be clawed back. So it's fantastic. Now, when we do the transfer and we do a transfer over, this came to me, and I'm sure I'm going to bring Tim on in a second now to go through it. But essentially, my thinking is that if we're doing consideration, why not pay consideration by way of a loan or a promissory note? So the transfers over to our family protection trust. Then from our family protection trust, what we can do from there is essentially we can use a promissory note or a loan agreement. Now that can be paid off over time, because the reverse side of the equation, if we remember up here, is that we got license fees coming out. So over time, license fees will pay off that loan. Alternatively, we've got a promissory note and it's sitting inside a discretionary trust. We might decide to wind up that discretionary trust, pay out that capital, so by way of the promissory note going out to the beneficiaries, who can then settle that back into or endorse it over by way of a gift into the family protection trust. So again, that's not a bad little strategy there to have a look at as well. So the final slide before we get to Tim is we need to set up a protection entity, such as a leading member discretionary trust or a family protection trust. So the first thing that I was looking when I went through that you'll see the wizard or our interview is I'll probably go ahead and put in an option there to set up the family protection trust, much the same as we have with our ordinary protector. We'll also probably put in an ability to do a loan agreement or a promissory note in terms of that. But again, I'm open up to all of your potential options we've got there. If it's a small business, then we obviously, when we're transferring the assets over, we talked about capital gains tax. But my feeling there is that we can use the small business concessions so that when it's transferred over, there shouldn't be a huge amount of issues there. Can it work? Would it work for an SMSF? Very unlikely, mainly because Section 66 wouldn't enable us to transfer assets such as logos, trademarks, etc., because it's not business real property. If it's in-house assets, less than 5% of the value of the fund, absolutely we can transfer over and license it back. So that's quite an interesting one, because it would be an in-house asset, but we stay under the 5% rule, which Section 66 has a specific exemption for. Anyway, what I'll do is I'll just get Tim to come in here, Tim, and I know you're in a very good position there. But if you want to just go through and look, this comes back from a lot of the risk work that you've been doing, but give us your feelings and how you market it, and more importantly, what the value is of this strategy for clients, and then more importantly, what advisors should charge.
Definitely. I've just changed my microphone. Can you hear me clearly now?
Yeah, I can hear you. It's a bit soft, but that might be.
Actually, I might just go back to another one. Hang on a sec.
No, that's fine. It's because my.
Is that one okay?
Yeah, that's
okay.
Perfect.
Fantastic. Look, as you said earlier, every client wants this. I just say to my clients, look, you're growing a business. Everyone wants to keep tax down, but you focus so much on everything that you're doing every day, but you've got to think of the end game. At the end, it needs to be left to someone. And if someone takes it from you, all your hard work over the next 5, 10, 20 years, or your hard work up to now, it's just been an absolute waste. So I just use the words, would you like to keep this in your family bloodline? And every client goes, yes. And so in Change CPS, we've got, using our VPP, value plan price method, a way of explaining how to, the importance of doing this. So everything that you're talking about leading up to, we've got like the front end to explain it to clients. Now we charge $5,000 per property. And if it's a business, we'll probably charge between 4 and 5. If it's a smaller business, maybe a little bit less, but normally 5 is the amount that we look at, plus GST. And we've not had pushback on price once. I've got one client I'm actually doing 20 of these for. I've done the first 4 and they're registered. I've got the next 3 on my desk at home. I've got another 13 to go. Every single client I'm talking to over the next 12 months, I don't do the day-to-day accounting work, but I get involved in strategy. And this is what I'm talking to clients about. Family Protection Trust, get the business protector set up, get the protectors on the other properties, wrap things around it like your wills, powers of attorney, and successor directors. And clients love it. They tell me they can sleep better at night now, which is great.
Yeah. Oh, it's absolutely crucial. I think if we have a look at Aldo come and said, well, if there's a loan agreement there, doesn't that put exposure or the risk with the loan agreement? Absolutely. So you've either got two ways of going. You can do it for, I mean, if you're going to do it, you might as well do it for nothing. So it's virtually nil consideration. You've then got to take into account the capital gains tax issues. But again, if you've got a capital gains that's deemed market value, you can use the CGT small business concessions. It's not a big issue. In terms of insolvency, of course, because there's been nil consideration, as long as a client was solvent at that time and you as the accountant have provided a solvency certificate, then you've got a 4-year clawback. So whichever way you want to go is a particular issue. But that's the beauty of this strategy, is you can sit down and work your way through with a client. Now, mind you,
can I just talk about the clawback just for a moment?
Yep,
this
sure.
is what a lot of accountants get scared on. And I think in the industry, you would have seen this as well when it comes to like doing wills or trust deeds or other things. An accountant might have heard a lawyer say something 10 years ago, or they hear some scuttlebutt and they get totally freaked out about it. The big question I'm asked all the time is, oh, but clawbacks, and accountants get so worried about clawbacks. And we've got to sit and think about this logically. If you're in a position, as Grant said, if you're in a solvent position and you don't have any creditors harassing you at this point in time, you can do what you want with your money. You can give it, you can give Grant $1 million, you can give me $1 million, you can give anyone $1 million. Now, after the event, if something happens, sure, what you've done is you've put it in the right spot in Family Protection Trust array from any creditors. A creditor's got to go and spend good money with a lawyer to go to court, and they have to argue that you transferred this asset before the creditor even came into existence. Now, Grant, I've never seen that done, but that's going to cost 50 to 100 grand minimum to go to court before you even have to start raising a defence. And the easiest defence was, this is the date I did it. Who were you? When did this happen? There is no logic. There's no reason that argument could ever get up in court. Now, I've never seen a legal case with that. So what I'm saying to the accountants out there, don't be spooked by people saying, oh, but the 4-year clawback. I don't think personally the 4-year clawback has a chance in hell of succeeding if you don't have creditors
at the time
that you're trying to afford at the time that you do this, and it's all documented properly. So really think about that. That just makes commercial common sense, not the kind of legal scared, you can't do it. Look, and even if it was a 50-50 chance, you know what? I'd do it. You put up as many barriers that you can anyway, and at the other side then pay to have a crack. You're not going to sit there with your door open saying, come and take my assets. So get a bit of fight in you, accountants. Come on, protect your clients' assets and protect your assets.
Absolutely. And I think there's a couple of areas that I can talk about on that specifically, is that when we go through, obviously with strategies like this, a classic one would have been a Bamford. So I still see to this day people running really old trust deeds, and particularly where there's a divorce or something goes on. I came across one yesterday. To vary the deed, there was one sentence that was 350 words long. The deed was going back to the 2000s. And again, there's been this myth, and this thing is that as accountants, they're extremely scared about obviously upgrading deeds. Whereas the Commissioner's got a determination, TD 2012/21, whereupon it says that you can go and upgrade deed, beneficiaries, change appointors, change trustees. Effectively, you can do everything, even change the vesting as long as it stays within the relevant vesting standards under the states. And there's not going to be a resettlement. There's no capital gains tax and there's no stamp duties. And this is authority up to the federal and the high court. But again, there's still accountants out there saying, well, no, I don't want to touch it because I'm frightened of resettlement. So again, I think that's pretty important as well. The other one, again, is the family allowance agreement, which we're going to talk about tomorrow, is that if we can put in place a family allowance agreement between a member or a couple sitting in a self-managed super fund down to their adult children, it's meaningful and it's for the purpose of looking after the adult children and their family. Potentially all of that family will be a financial dependent, such that when we transfer the superannuation out to a SMSF testamentary trust, if you haven't seen that, you're going to see one tomorrow. It's very exciting that when that goes out, it comes out tax-free. Now, again, you might argue, well, I don't know whether it's going to work or not, but isn't that stupid? Isn't it better to put it in place and then find a situation that if it's in place, it actually works? And look, my feeling, we've done all the authority, it all stacks up, and it's absolutely crucial. If there's ATO guidelines, you'll see when we go to family allowances tomorrow, just paying kids uni fees effectively is, they make them financially dependent. Paying rent makes them financially dependent. So the Commissioner's come out with a whole lot of guidelines on this. And again, we can't sweep it under the carpet. You've got to be, as Tim said, you have to be a passionate, proactive accountant. If you fail to do so, you're going to be left behind doing compliance, which the ATO, if my understanding is correct, is increasingly going to compete for, but they've got the lowest prices in town. Is that correct, Tim?
100%. And look, there's always going to be compliance work for accountants, but I seriously, over the next 5 to 10 years, I can see things like auto calculations of BAS starting to appear. We're definitely going to see a push from the government to eliminate personal tax returns for the basic ones. So I'm not saying compliance is dead, but I'm saying that there's different areas that we're able to move into as accountants and advisors. I look at my value add. Am I best helping my clients, with tax returns, or I'm best helping my clients with asset protection, strategic matters moving forward? Well, I know the answer to that. This is where my focus is going to be. Yeah, I've got my team doing the day-to-day compliance stuff. As the owner of my business, this is where my time is best spent and gives me the biggest return, and clients love it.
Yeah, and particularly utilising our automation, our solutions and the technology. I saw some of the discussion in the chat room about PPSR, land titles, all of that. To go to, if you went back about 18 months to 2 years ago, honestly, it was bloody hard. You try to go to a solicitor, they'd want to review all the documents, blah, blah, blah. They didn't know what they were doing, and they try and charge $2,000 for it. Now, we've got Michael Jeffries from Avenum Optimum. He'll do all your PPSR, do your land titles, does everything, so that really it's where it should be. And I think, Tim, you evoked this fact is that at all points in time over the lifetime of a client, whether it's before, during, or even after their life, that effectively the accountant should be the one who's the go-to person.
100%. The accountant should coordinate all of this stuff. And, even if you don't give wealth advice, accountants, you need to coordinate everything that your client needs, and you bring in experts as and when you need it. In fact, I'm working on something in GPS that'll be out in 6 to 12 months that is going to link everything together, like your clients moving forward, your asset protection, your estate planning, and it'll make it easy for your clients to instantly see these things that need to happen. I might give a glimpse of this tomorrow, just a glimpse.
Yeah, that'd be great. And with this business protector, I know you've built quite a lot around the protector itself, but with this specific strategy, are we going to see something that a bit of a heads up? Is Change GPS going to put something out for it?
Yeah, look, it won't be ready for tomorrow because you're just launching this today. But
come on, you can rip up stuff really quickly.
Look, it's. I want to have it perfect. We've got a 25-page document which you can trim back. It's got everything in it for advanced estate planning, which covers everything: leading member information, the protector for homes, PPSR, loan security, all the rest of it. I'll then add in a separate section for the business protector, go through it with the diagrams. So the advantage for those using Change GPS, you can just use it instantly and get this out. Charge $1,500 even for this advice piece. When you see the advice piece and Change GPS members, it's already there for you under asset protection, estate planning. That's what you use to help the clients to understand what you're recommending to generate via LightYear Docs.
Absolutely. And so let's get to the actual product. So what you'll see, or the service with LightYear Docs, this is our front page. you just simply go into the documents. Here, you can just simply put in, I find it's easy, you just put in protector, and you can see there you've got the business protector or the ordinary protector there as well. Or alternatively, you can go in and scout around. The problem is we've got more than 130 documents and automations these days, so it takes a while. You can always come to support and ask us. So you'll find it here into other business. You've got there the business protector. Now notice here it's $695. The reason we've done that is because there's quite a few documents embedded in there. Now all of our basic documents are going to be $99, but with this business protector, because it's a great value add for you guys, what we've got is a pricing there of $695. It's all signed off by Abbott-Family lawyers, and then you're off and running. So I'm going to start the document. I'm going to put it into my folder. I'll put it into the Abbott demo folder, and then I'm going to put Smith Business Protector. Now, this one has got a little bit of nous to it. And it's really a good accounting / document, because remember, if we're breaking apart absolutely everything in terms of our goodwill, then essentially what we're doing is there is going to be no goodwill left. So we end up transferring these assets over. So I've got the Smith Business Protector. I can use Abbott-Family, AM001, my logo, or you can use your logo. So we can put the common parties in there. So let's go through and have a look at our common parties. This just makes it easy for the CRM. So what I've got is I've got a couple of trustee companies here. If I was individuals, I'd put them in here. So let's say we've got Smith Nominees, and that is the trustee company for my discretionary trust. So I put in the ABN, so on and so forth, and then I'm going to put in the street line address. So again, I can't type, but I'm pretty good. So Naomi's probably sitting up at Port Lincoln laughing at me typing away here. But anyway, see, I can't even get Sydney right, I don't think. So Sydney. So we've got in there, we've got sole director, just to make things easy. And I've got James Smith. Now I'm going to add another one here. So I've got my Family Protection Trust, and I've got my Family Protection Nominees, which I've set up. And again, that's going to be like a leading member company that we've got there. Exactly the same sort of thing, because it's no good setting up with ordinary standard. You can see there I can just, with common address, so just pull that up. And then I've got to do the directors. So again, I'll just use James Smith there to make it easy for us. So I've got all those common addresses, which are the key there. So I've put in there the transferor, which is the family trust, the discretionary trust, and that's going to transfer the property over to the Family Protection Trust. As I said before, I will put in an option here. Do you want to set up the Family Protection Trust? So the transferor is our Smith Family Trust. Now, because of my automation, all I have to do is I've got the trustee company, which I've already put in there. So that's all been pre-done for me, as you can see there. So I don't have to do anything. I'll then go to the transferee. And again, that's going to be my Smith Family Protection Trust. Now, if you wanted to, of course, you could have the spouse as the transferee, but again, it just doesn't make sense, because we've got that litigation exposure. So the transferred property. Now, this is where you have to do, we look at the state we're going to do this agreement from. So it's going to be New South Wales. Is there consideration for the assignment? Yes. So let's say the consideration is $1 million for the assignment. Now we go through the assigned property, and you can see here there's a drop-down box. So we're going to do trademark. So it's going to be trademark for super style. We're then going to go in and we're going to say, okay, database, which we haven't got that. We can put that, yeah. So property there is more just ordinary property. So we could put 1,000 client data base and 5,000 prospects, which is essentially worth quite a bit. We can put in there, for example, marketing processes. So for that, we need to sit down and obviously build our marketing files. Again, a lot of this stuff is extra work that you can help the client build this and deliver it in as a value-added package. The more we can get in there, the more value we can shift to that family protection trust. So marketing for super style. And remember, what we're doing is not only just for our family protection trust, but potentially this is a franchisable interest. So right at the start of this is quite a bit of work there for the accountant as well. And of course, you've got the family protection trust, you've got the licensing, you've got the transfer, then effectively there's a lot there for you to do on an ongoing basis. So we've got the property that we're going to transfer over for $1 million. So again, that's got to be the market value. So the licensor is pretty easy because the property is now in the Smith Family Protection Trust. We know that we've got the party there is family protection nominees. The licensee is again the discretionary trust. So the Smith Family Trust. If we want to keep the business there, of course, we could transfer it to a brand new trust if we decided to do so. So the trustee company is again Smith Nominees. Now we go down for the agreement. Again, it's going to be in New South Wales. How long is the period? I would do 10 years. When does the contract commence? Let's say it's starting tomorrow. When does it finish? Obviously, it's going to be the 26th of the 3rd, 2031. So it actually won't be the 26th, it'll be the 25th because it's going for 10 years. Oops, sorry. 25th. I feel like spectators here. Is there a further option? Yes. So again, we can put in there another 10 years. When does that have to be? When's that option going to be exercised? What's the latest date? So this comes in a true licensing agreement. We're going to have it a month before, so the 25th of February 2031. Now here we can actually do again. This is from a true franchisable proper license agreement. So we can put in there, are there any conditions in relation to the license? So in that one, we could, for example, it is exclusive to South Australia only. What is the licensed property? Then effectively what we've got there is those three elements there. We've got logos. We've also got the databases. And what I might do is I'll make sure that we can switch that over, or I'll get our guy to copy and paste it there as well. And then we've got marketing processes. So that goes over. So the fees. So the question is there an upfront fee to be paid to the licensee? So again, we could choose, for example, an upfront fee, which is to be paid, and that might well be $100,000. So we put in $100,000 sitting in there. So that will ameliorate. In fact, I don't think that's okay. So I did too much. Sorry about that. That's $1 million. Just go through to. Now that'd be good if we actually charge an upfront fee for ongoing license fee. So the timing of the license fee, it's monthly. The amount of the license fee, let's say it's $5,000 per month. And are there any other fees? For example, there might be six monthly review fees.
Graham, what if you did an upfront license?
Yeah, you can do that. So you can do an
advantage there, depending on what happens both ways.
Over the license back for that 10 years. The only issue from that is that obviously if you're paying it, you won't necessarily, because the license is actually I should have think about this, because you're actually going to get a deduction for the license. But of course, there's only the 13-month rule. So from a tax perspective, which I wanted to talk about, this works out very good tax-wise. So we've transferred over, we're licensing back, pushing money from our trading company back into the Family Protection Trust, and we're getting a tax deduction for it. So for me, it's like, this is why it's such an amazing strategy. But you're probably right, Tim, we could have a look at that $1 million upfront payment, so money goes in and out for that one. It's quite easy to show that there's a market value there. We've just got to watch out for the tax deduction. But it doesn't matter, the tax deduction will just be spread over that 10-year period, if that makes sense. But good question. Again, when you come up with these strategies, don't expect them, or the solutions, don't expect them to be all up and ready right from the start, because obviously we all work, you come up with solutions. All of you guys, when you start utilising these from a practical perspective, you say, Grant, can we add this? Can we put this in? And I think this is really important. Security agreements to lodge the PPSR. That would only be if there's a loan agreement, because the assets are actually have been transferred over. So you probably don't need to have a security agreement for the PPSR. Can you transfer IP using this? Absolutely, John. So originally the transfer of the license agreement was for logos, trademarks, but anything that's sitting in the business can be transferred. You just obviously have to watch out for capital gains tax and potentially stamp duties. How is the market value of the assigned property determined? Again, you're just going to need to make sure it's market value, which is going to come up for capital gains tax purposes. So you can do a search. I haven't got time today, but you can do a search on the ATO, have a look at transfers between related parties. The Commissioner goes in as to what he requires from a valuation perspective, Chris. If you can, how do you describe what the IP is? IP, break it down to, for example, I think, John, it could be the marketing processes are IP, so they're copyright. Documents you have are copyright. If you look at logos, they're called trademarks. You may well have patents on a process, so it could be a trademark. So effectively, intellectual property are either trademarks, they're copyright, or alternatively, they're patents. And it's definitely, you want to make sure you secure it through the Intellectual Property Association of Australia, which I think. So if you transfer equipment that's on the property of licensee, you want a PPSR on that, that's true. Let's have a look at a couple more. What I'll do is I'll just download there. Okay, so trademarks, well done. So you guys have got, in fact, the license would be indicative, so that's really good. Yeah, so I'm just having a look at all your chats. It's fantastic, well done. So I've done the business protector. As I said before, I'm going to put in there, if you guys think, I'd like you to listen to this again, take it away and have a really good think about it, because there's huge value in that. As I said before, one of the most important key criteria here for the business protector to work is the determination of what the assets are. John, for example, what the IP is, and if you've got a trademark, as has been noted in the chat forum, there'll be a ID number there. If there's marketing processes, then obviously having a folder, having those secured somewhere, all of those, you're going to have to sit down and then work out a valuation. So there's quite a bit of work there as well, establishing the Family Protection Trust, so that by and of itself, it's probably a good $5,000 strategy. But once you add all this other stuff in, you know, it could go up to $8,000 to $10,000 or $11,000. When if they're a very, very successful company, I would say it's probably even greater still. So let's go down. Deed of transfer of the property. So you see there, we've done it by way of a deed rather than a contract. The reason we do that is that if it's a deed, it's still covered under contract law, but you also pick up the equity law as well, meaning that it's enforceable. There's obviously a whole lot of areas around equity that can be used there, equity law. So I prefer to use a deed. It's a lot more solemn than a contract. So we've got that going from the transferor to the transferee, the family protection. I've got all the assignment there. So what I will do though is I'll look at it there. You can see there, obviously, it picked up the $1 million, the transfer over, which was okay. I could go back and delete that. So executed as a deed by the parties between the two, and then we've got the transfer of the property. So these are the three areas that are sitting there. We then go into the license and support agreement, which is obviously the more robust of it. We've got the licensor and the licensee there again. We go through the license, what's being licensed. We've got the terms and conditions of the license, so on and so forth. All confidential information, all of that. So if you've seen our license agreements before, they're extremely robust. In fact, they're the same ones that we use for those of you who are lucky enough to be licensees of our system. And we've got the agreement details, the licensor, the licensee. We need to put in their phone and mobile phone. So I'll just check. We've got the various areas there and the pricing. So that's our business protector there. So it's a pretty exciting innovation. So when we go down, let's have a look at if you've got any other questions there. Okay, so perfect. Okay, so what's the lower limit? Now here's the thing is, from our perspective, and this is fairly important, I've been talking to a few people around this, is the strategy is $6.95 for pay-as-you-go. But importantly, for most of you, if you're on a top level, our strategist, which enables you to use the Moat Castle, the Business Protector, the Protector, Successor Director Solution, all these, super value-added strategies for usually no more than $6.95 a month, maximum $7.95. Then if you have a look at that, you only need to do one of these a month, and it means that everything else you do on our platform, whether you're setting up companies, asset fees, obviously, trusts, family protection trusts, leading member trustees, loan agreements, license agreements, SMSFs, pensions, investment strategies, everything else is going to be basically free for you. And I think that that's the crucial, is that, from our perspective, we've got such low value-added prices, but each week, for example, our strategist members, I've now dumped on you, not dumped, I've actually launched for you this Business Protector, which I believe every one of your small business to medium business clients can have. So I know with David the other day, we sort of sat down and talked with one of their clients. If they haven't got a huge amount of wherewithal, but they are still concerned about the business protection, if you want, just simply say, okay, well, what we're going to do is we'll charge you $2,500. You can see we've done it pretty quickly. But as it goes up to a certain level, but once they increase their goodwill, then there's another payment that can be made. So essentially, the pricing is up to you to get the maximum value. What size client is the smallest? I don't believe there is. Obviously, if someone starts up, you're putting that protection in. But I might just hand it over to Tim, because Tim's obviously got some ideas around that as well.
There's so many ways you can do it. I think a lot on this web event might be thinking, oh, look, we're talking about transfer of goodwill of other things and triggering CGT. A lot of ways you can do it. Well, and that might be a good thing, take advantage of small business tax concessions and also to throw some money into super possibly. So use this as a restructuring trigger point. What we've done for some clients is we might have a holding company and a trading company. We would transfer plant and equipment and other things at written down value to the holding company. And then we would enter a services agreement to license them back. Or you might have created some, if you're a business owner, they typically don't have employment agreements, but they've created IP. So what you could do is use Grant's assignment agreement to assign the IP into the holding entity, then use the Business Protector to license that back. And you could start small on a percentage of turnover, and as you can prove that it's actually generating income for the trading company, you can pump that up and make it larger. So there's a number of ways you can do it just to pull assets out. If you have to leave the goodwill in the trading company, that's fantastic. But what you can do is, pay a dividend out and then take a security over an unpaid dividend. There's a whole range of other things that you can do. So yeah, look, I think we'll cover off some of them tomorrow.
Yeah, I know. So it's we'll talk about a lot tomorrow. John's come in and quite interesting that this is something you've been hassling me about for a while, Tim, and says, Does LightYear provide ability to set up fixed and floating charge for a corporate beneficiary who lends money back to the trading company so as to establish a secured creditor? Absolutely. So we are coming in with another strategy on that, which will be the ability for those, the people, the innovators, the entrepreneurs who put money into a company to actually turn that into a loan and then secure it against creditors. So again, that'll be another strategy that's coming out. And you can see, honestly, the roadmap of strategies we've got coming out for the rest of the year. Each one of them is a real high value, a high fee earning strategy. So we're not about docs anymore. We're about solutions for our clients. And you'll find that there's no pushback on this sort of stuff. Why would anyone push back against protecting your family wealth for your bloodline? It just doesn't make sense.
Accountants that, I hear often that they're kind of, I don't want to be seen to be selling and whatever. Seriously, your clients are wanting you to tell them what they can do to protect their assets. If you don't do this and you're aware of this, I'm going to make a big call. I'm going to say you're negligent as an accountant. Don't want to offend you, but seriously, if you've got the power to assist, this is the best stuff, the estate planning and asset protection. This is the best way that you can help your clients. So spend time on grants webinars, get your head around this information, focus on doing this. And that's what SPEP is all about, to give you the confidence.
Aldo's actually got a really good question that I haven't thought about. So taking for security for unpaid dividends, would that impact a credit rating?
Taking a security over it, I would not think so, because really it's just registering PPSR or something. So that's not a bad item. I mean, I was looking at credit rating reports for some clients the other day, and as long as things are explainable, if you're looking to get a loan, and what I've seen in the past, people say, well, what have been these things here? And as long as you explain them, that's never affected anything. And I'm a loan broker. We do a fair bit of this.
Yeah. Good question, Sian. Husband and wife are both 50-50 working in their business. Can the protector be used to protect both their interests in the event of a divorce? Absolutely. So, I mean, it's probably not a bad idea to split it anyway. And you'll see with that business protector, you can add a transferor if you want, quite simply. So it's well worthwhile.
I'd just say to Aldo as well, if you're concerned about credit ratings, I'm more concerned about your client losing all their assets if they get sued. So again, you've got to have a look at, explain it to your client, let them make the judgment call. What you need to do is make them aware of the options, because if they come back to you, if the crap hits the fan and they lose their business, they'd say, hey, listen, why didn't you help me with this? So I'd say, look, present your client, present that information to them, let them make that judgment call, and then take it from there. At least you can let them know what the options are. Let them make that call.
Tomorrow we've got our Master Strategy Day. If you haven't signed up yet, you can just go onto our website, use either Change GPS or Strategist as a code to get a $50 discount. But look, I'm super pumped for it, and I'm sure Tim is as well. So we've got lots of great stuff coming through. So there'll be a lot of razzle dazzle, I can tell you, on that one. But
the live studio audience as well.
I know it's a live studio, so it's actually in Tim's boardroom. So it's rather than this, it's as if you are going to be in our boardroom with us. So it's going to be a very intimate event. We've got 3 case studies. Do you want to just go through the case studies really quickly, Tim?
Certainly.
Just a broad background.
So we want to make it as realistic as possible. So the first one, we're going to have a case study of a smaller client, mum and dad. Mum's a doctor, dad's a stay-at-home dad, and they've got a family property, and they've got retail super, and they've probably got $1 million worth of life cover each. So looking at what happens in the event of, look, how should the wills and enduring powers of attorney be structured? Should a family protection trust be used? How could it be used? That's a real simplified one. Next one, we've got a single person with running a business. Once again, no self-managed super fund, but single person running a business. How can we protect everything? Third one, that's your more complex clients. So you've got mum and dad, multiple businesses, investment properties, self-managed super fund. And we're going to go through especially what happens if mum dies, if dad dies, or if both die. What happens when the teenage kids inherit everything? How does a leading member trust work to keep it in the bloodline? And there's some really new strategies that Grant has thought up that links into how do you use a leading member trust if mum and dad are dead, but we've got the kids there, and how do we help the kids to be able to benefit from that. But if they're in a relationship that goes bad, how can those assets not be taken away from the kids? Very, very important.
Absolutely crucial. Got a couple other questions. Aldo, this is a perfect statement. Asset protection is the easiest way to differentiate your firm and the virtually no competing accounting firms, and it doesn't revolve around tax. Hallelujah. I mean, that's the whole thing, is that we don't have to go in, and it doesn't involve super. In fact, I saw a couple of the people who've been around for Gemma Cooper and Gemma Cooper Sanderson have been around for like 20 years saying how bloody hard super is at the moment. And guess what? This is, I'll be going through a lot of super. I don't find it hard. I just think anyway, I won't go through that. But we'll go through a lot of super strategies tomorrow. But essentially this is, I'm all in on this. I was all in on SMSFs in their early days. Now I'm all in that succession, asset protection, estate planning space, because I follow Aldo. There's $7 trillion that our clients want protection. And I just saw the other day when I sat down with David and his clients, as we were walking past, and he's a lovely gentleman, and he said, look, I've talked about this to 7 of my clients, and I haven't received any pushback whatsoever. And you won't, because it's hitting the nail on the head. And it's good. That's what I love doing, is that when no one else is doing it, that's when you can charge your premium fees. At one stage, it's going to become ubiquitous, and so then it'll be a lot harder. Daisy, in terms of the Master Strategy Day, there'll be something coming out today with the agenda items, the timings, your login for the Vimeo files, and also any other materials as well. So wait for that, look out for that, and looking forward to seeing you all tomorrow. And again, Tim, thanks very much for taking time out of your busy session. What's it been like there?
It's been good. Going through best interest duty and lending, and realising how crazy and wacky this world is with red tape and regulation. But we'll keep fighting through it and try to help the mums out of Australia to be better off. That's what it's all about.
Exactly. Okay, guys, thanks for that. And I'll see you tomorrow morning, Tim, at bright and early. So it's
tomorrow morning. I'll get us 2 strong black coffees and we'll kick off well.
I know it's an 8:30 a.m. start for Eastern Standard Time. So it's 7:30 up for us in Brisbane. And God forbid the guys over in Perth, we love you and we really appreciate it. But just know that everything's going to be recorded anyway. Anyway, it's Grant Abbott signing off. See you tomorrow, Tim.
See ya.
Bye.